like where a crime is clear, in which case he can do anything for as long as he avoids the law because the law is clear. These are some of my statements on the law itself.
Okay, one of the, still on the content, no? I believe ASEC already mentioned that strictly speaking, your cybercrime legislation does not contain content-related provisions. Another question sent in online regarding content is, how do you intend to pursue and prosecute spammers? The sub-question is, what about spammers abroad?
Actually, the provision on spamming in the law is quite broad. In other words, malaki yung out. No? If you're engaging in unsolicited commercial communication, the law doesn't require you to have a pre-existing relationship with the person to whom you're sending the email. In other words, that person, you could buy that person's information, right, his email address from whoever's selling information, and then you can send it, but there are just requirements. There's an opt-out provision, and you identify yourself. Now, actually, what people don't understand is that there's a lot of overlap between this law, the 10175, and the data privacy law, which is the 10173. Both laws lobbied, signed close together and lobbied, I understand, by the Business Processing Association. People haven't understood yet the exact impact of the data privacy law, but I can tell you, like the example given earlier, about saying, releasing information about the health issues of everyone in the DOJ forum has AIDS. So that would be a punishable act under the data privacy law, because that's sensitive personal information about the health of individuals. And that would be punishable under that law. And that's the problem. And going to the problem of Section 6 and Section 7, it would be also punishable under cybercrime law if you do it via tweeting. And going to the double jeopardy provision, I understand Section 17, which was pointed out earlier, which is similar to Section 7, or almost exactly worded. That is true. There have been other statutes, such as BP 22, where it says that prosecution under BP 22 is without prejudice of prosecution under the revised penal code. But in those cases, those are two different acts. The act of estafa has the included there is the intent to defraud, whereas in bouncing checks, there's none. It's the issuance of a bad check. So those are two different crimes. But under the cybercrime law, which I think that why it's covered by double jeopardy, it's exactly the same crime. And you're being punished twice, because under the revised penal code, you're punished, and also under the Cybercrime Act, but 1 degree higher. I'd just like to mention one more thing about that this is a content-neutral statute. It is not, because Section 6 incorporates not just the revised penal code, but all other criminal statutes existing in the books. The Cybercrime Prevention Act isn't just about cybercrimes, it's about all crimes. Any crime you can think of. Violation of intellectual property right, covered by the cybercrime law. And intellectual property right is certainly content provided. In fact, even economic laws are included. For example, I think it's a crime to sell, to engage in retail trade if you're not 100% Filipino-owned. Under Section 19, on prima facie finding that you're violating the law, your site may be blocked. Well, does that mean that the Secretary of Justice can block a site like, say, eBay, or a site like Amazon.com, which is engaging in retail trade in this country, and it's not 100% Filipino-owned? These are the questions that, so these provisions, independently of each other, may be okay, but when you interrelate them, and when you interrelate them to the larger scope, because it's so broad, and under Section 6, Section 6 of the law basically gobbles up all other laws. Then when you connect all of these dots, it's pretty scary, the kind of power under Section 19. So it's not just libel, it's not just content, it's economic activities. I think that would fall under the jurisdiction of the DOJ under Section 19, or the takedown provision.
Yes, thank you, Attorney JJ. Further questions? Yes.
I'd just like to answer a question with regards to the how do you prosecute spammers or phishers when the attackers are nebulous. One way of doing it is to follow the money. Since December last year, there are multiple banks that have been hit by phishing. Real money has been transferred in hundreds of thousands of And right now, follow the money. They got the person, and they're not going to charge that person. Their lawyers are just working on this new cybercrime law. But that's how you attack the phishers and the spammers and the scammers. Follow the money, and there would be a corresponding decrease in phishing attacks against your organization.
Yes, thank you, Drek. So your point is follow the money. In other words, they've been doing this even before the Cybercrime Act was enacted. Okay, thank you. Ma'am?
Magandang tanghali sa inyong lahat. I'm Commissioner Coco Kisumbing from the Commission on Human Rights. Well, just a warning in terms of that case. Please try not to violate the rights of those people and make and apply the crime ex post facto. We at the CHR understand the very difficult and delicate balance between fighting and preventing crime, but also protecting, respecting, and promoting human rights. And while, yes, there is a need, definitely, and there is a human rights aspect in terms of fighting some cybercrimes, especially the attacks on women and children. So thank you for putting that in. But we really need to highlight that the Philippines has obligations in our Constitution and in international law, in treaties. Hindi pinaka-importante itong cyber security, the covenant on cybercrime. The Philippines has, since the time after the People Power Revolution, been a state party to international human rights treaties that protect fundamental freedoms like freedom of expression and the right to be safe in our personal correspondence and other effects. So there's that balance. We know that there are already court cases, complaints about especially the libel provision. But I'd just like to highlight, if we can work on that in the IRR, please let's do that. It would have been so much better if this was discussed very thoroughly in the making of the law, because alam niyo naman, dagdag yan sa trabaho namin with our budget getting cut every year for the past 3 years. This is just one more area where we will probably be getting complaints. The Philippines had already been told by the UN treaty body on civil and political rights that the existing RPC on libel is not consistent with our obligations. It says imprisoning people for libel and defamation is never appropriate. So the fact that we even included it in a new law, the fact that we increased, is not a step forward, especially because we have the obligation to create and maintain a legal framework, a legal environment where our rights can be fully enjoyed and even to promote. So we're hoping for some improvements in this. Definitely we look forward to the steps as ASEC had mentioned in guarding the people who are supposed to be implementing it. But we also promise that the CHR will be active in formatting or formulating any such IRR, but we will also be watching. Thank you.
Thank you, Commissioner. By the way, we have some people from the Information Communications Technology Office here. Commissioner, I believe there was an initiative. The workshop or meeting hasn't actually been called, but I believe they were planning to draft something like an Internet Bill of Rights. Anyway, yes, Carlo.
Hi, I'm Carlo. I work for a TV network. I'm here mostly as a blogger. So I'm not a lawyer, so some of the legal speak gets lost on me. So I'll try to be very, kumbaga, layman's term. Hello. Ayan. Okay. First, I just have one quick comment. I think, ASEC, if you were explaining this at the very start, I mean, noong time na ina-announce yung bill, the uproar wouldn't be as bad. So thank you for going through the lengths of explaining everything that you just